to segment 5.5, Enforcement of Rights. I'm in the textbook on page 234. Now there's actually a few reasons why it is that I included an entire complaint here beginning on page 235. You may not have seen a complaint before. You may have, in fact, you've read some cases in the book, in the textbook for this course, but cases often stem or actual final orders generally with respect to an entire case that has gone on for an entire time. What you see here on page 235 is the original complaint filed by Microsoft. Actually, it's by Microsoft, or it's the USA on behalf of Microsoft of what's going on here, because this is an international type case. But what's occurring is very much you see all the basis for the dispute as far as what is going on here. And I think it's interesting to sometimes see the raw document rather than just the text that is from the document, so you get a sense as to what is actually being presented before the court. As far as questions are taken on the questions, the first is it can be presumed that Microsoft probably takes adequate steps to protect its information. And so there's confidentiality agreements, software keys, Mac device identification. So in short, they are very much taking steps to make sure that secrecy is being maintained. And obviously this would be information that is providing a competitive advantage to Microsoft, and they're taking steps to maintain it. So the question is, in what ways did Kipkalo actually take steps to subvert the adequate steps that Microsoft has taken? And we will discuss that in our lecture. We will also look at to what degree Kipkalo actually knowingly released this information. It's one thing if, let's say, they stole the information and then they sold it to a private party or something. And now that doesn't necessarily diminish the illegality of their action. But one of the things that they're doing is, if they knew that what they were doing was actually completely wrong, then that would increase the likelihood that the courts would find enforcement from Microsoft's behalf. So here, if it was just merely a casual taking of information that shouldn't have been taken, that's one aspect. But if he went in knowing full well it was illegal, pulled it out, took it, and then sold it additionally in a legal manner, then all that would contribute to this overall notion that it was not, that there was a greater likelihood that they would rule from Microsoft's favor. So let's look a little bit at misappropriation, and then we'll get into this case as far as the facts and the results of it.
What is misappropriation? The Uniform Trade Secrets Act enforcement provisions allow companies and individuals to protect information that qualifies as a trade secret from actual or threatened misappropriation. Misappropriation is 1. Disclosure or use of a trade secret without consent. 2. Acquisition of a trade secret through improper means, or acquisition of a trade secret by another, by a person who knows or has reason to know the trade secret was acquired by improper means. Improper means includes theft, bribery, misrepresentation, breach of a duty to maintain secrecy, or espionage through electronic or other means. When would a party allege actual misappropriation? In cases of actual misappropriation, the wrong has already occurred, and the trade secret owner may seek judicial intervention concerning any legal rights that were violated. This is true regardless of whether the misappropriator obtained the secret without the owner's consent or originally with consent, but later used the secret for the misappropriator's own gain. The burden of proof in an actual, as opposed to a threatened, misappropriation case falls on the trade secret owner alleging misappropriation. This burden of proof requires the trade secret owner to demonstrate that he or she was in possession of knowledge or information that was not generally known and was valuable because it was not generally known, and that the knowledge or information was subject to reasonable efforts to maintain its secrecy. Proving the elements necessary to make out a trade secret case can be challenging. The best way to establish a foundation for successful prosecution of trade secret misappropriation is to follow a written trade secret protection plan. When would a party allege threatened misappropriation? In cases of alleged threatened misappropriation, the trade secret owner does not contend that their trade secrets have already been misappropriated, but rather that unless some action is taken, their trade secrets will be misappropriated in the future. Threatened misappropriation cases often arise when a highly skilled or trained employee who has been exposed to a company's trade secrets leaves the company and goes to work for a competitor. On the one hand, the former employer may have legitimate concerns about possible disclosure of its trade secrets to a competitor. On the other hand, the employee has a right to work for the employer of his choice. Courts are required to balance these competing interests. When faced with a situation where an employee who has been exposed to trade secrets leaves to work for a new employer, courts typically consider three factors. 1. Whether the former employer and the new employer are competitors. 2. Whether the employee's new position is comparable to his or her former position. And 3. The efficacy of steps taken by the new employer to prevent the misappropriation of trade secrets. Courts will not prohibit the wrongful use or disclosure of trade secrets based upon the mere suspicions of the trade secret owner that some misappropriation may occur. Rather, the trade secret owner is required to demonstrate that the concerns of misappropriation are legitimate and that misappropriation is likely to occur. What types of evidence can be used to support an allegation of threatened misappropriation? A trade secret owner may present direct or circumstantial evidence to demonstrate that there is an imminent threatened misappropriation of trade secrets. Direct evidence exists when the trade secret owner can demonstrate that action has already been taken or words have already been spoken that indicate a misappropriation of trade secrets is going to occur. Common examples of such direct evidence are statements made by the former employee or the new employer. Similarly, the new employer might make statements about the purpose of hiring the new employee, why other potential employees were rejected, or the nature of the duties the new employee will be required to perform. Based on evidence of such actions or statements, a court is likely to protect trade secrets by enjoining prospectively their wrongful use or disclosure. However, in most situations, direct evidence concerning the likelihood of misappropriation does not exist. In such cases, a trade secret owner can present circumstantial evidence to demonstrate that the unauthorized use or disclosure of trade secrets is eminently threatened. There are two types of circumstantial evidence. 1. Evidence demonstrating the intent of a party to elicit the wrongful disclosure of the trade secret. And 2. Evidence demonstrating that the wrongful disclosure or use of a trade secret is inevitable regardless of any party's intentions. Although circumstantial evidence is generally not considered as strong as direct evidence, it is clear that courts will issue injunctions prohibiting the misappropriation of trade secrets based solely on circumstantial evidence that indicates such activity is eminently likely to occur. For example, in PepsiCo Inc. versus Redmond, the defendant moved from a senior position at PepsiCo to a position at rival Quaker Oats Company, then owner of the Gatorade brand, which is now owned by Pepsi. The court held that it was proper for the district court to conclude that based on the defendant's access to Pepsi's trade secrets, it was inevitable as part of the defendant's new employment that the trade secrets would be relied on. The district court concluded that unless the defendant possessed an uncanny ability to compartmentalize information, he would necessarily make decisions for the new employer by relying on the trade secrets. This was true even though there was no direct evidence that Redmond disclosed any of Pepsi's trade secrets. A trade secret owner who suspects either actual or threatened misappropriation must act promptly to enforce his or her legal rights. Although the statute of limitations under the UTSA is 3 years, courts have the power to deny the relief requested by trade secret owners even when an action has been initiated within the statute of limitations period if the action has not been initiated promptly. The UTSA assumes that a trade secret owner who suspects misappropriation will move with reasonable alacrity to protect his or her intellectual property, and recognizes that if such action is not taken, then third parties may materially change their positions in a good faith belief that no trade secret rights have been violated.
All right, so when we look at, for example, the misappropriation type aspect, there are some things to keep in mind. So first off, what does actually misappropriation mean? And it may be construed by the courts as some acquisition of a trade secret or knowledge relating thereto by a person who knows or has reason to know that the trade secret was actually acquired by improper means. So misappropriation, namely, that they are receiving information that they know or should know was likely acquired in an illegal type manner. Misappropriation also includes the disclosure or use of a trade secret or another without express or implied consent by a person who, one, used improper means to acquire knowledge of the trade secret, or two, at the time of disclosure or use, knew or had reason to know that the knowledge of the trade secret was derived from or through a person who had utilized improper means, or acquired under circumstances giving rise to a duty to maintain its secrecy, or derived from or through a person who owed a duty to the person seeking relief to maintain its secrecy or limits its use. And last but not least, that disclosure or use of the trade secret of another without express or implied consent it occurs before a material change in the position of the individual knew or had reason to know that it was a trade secret. The knowledge of it had been acquired by accident or mistake. So when you look at this, it really comes down to two type of parts. One, the acquisition of information that you know or should know was acquired by improper means. And then two, the disclosure of that information or use of that information without express or implied consent. And this would make sense. That if you do have a secret and somebody else is stealing that secret, first off, if they receive that information and are now using that information in some way, the course we'll be looking at, did they even know that it was a secret, or should they have known that it was a secret? And two, are they using it in a manner that where they do not have express or implied consent? So this again looks at some of the factors that we'll look at, namely information that provides economic value or competitive advantage, and there were steps maintained to preserve its secrecy. And that kind of goes to whether or not there was express or implied consent would be directly tied to the factors of relating to whether or not the factors to preserve the secrecy of it as well. So here, for example, we have this Microsoft related case against Kip Kahlo, and you see some of the excerpts here from the complaint that was actually filed. So this was back in 2012, and Microsoft was alleging that Kip Kahlo went in and actually they went in to actually pull some of the latest files relating to Windows. And so it talks about how, for example, a pre-release of Windows 8 hot fixes. And then, so Kip Kahlo went in to Microsoft's server system, took that information, and then provided it to a blogger, which then actually released it to the public. So, and these fixes in particular were not sold separately, and they were only distributed through OEM type partners. In other words, the system kept it secure. It was only released in a private manner to specific channels, and that's one of the things that the court looked at. And not only that, but they looked at the measures taken by Microsoft to actually ensure that it was kept secret. So it says there, paragraph 22, the software at issue was custom developed code designed for internal Microsoft use in producing Windows operating system. The code was protected by copyright. It was kept confidential as a proprietary trade secret. Access and use of the software was controlled by the Windows Intellectual Property Security Program. Now, in the case itself, one of the, I think, telling things about it is that it actually looks at some of the steps that Kip Kahlo took to actually go ahead and actually receive this information. So there was this big investigation that actually went in, and they actually found that there was SDK files. That was that was the information that was taken by Kip Collo. But the interesting part is we were discussing before whether or not there was an access chain associated with accessing specific files, and that is exactly what Microsoft did here. They had trace evidence showing exactly when Kip Collo received the file, when he uploaded it to his SkyDrive, which is also owned by Microsoft, account, and when he actually shared that with the blogger. And now as far as the information is concerned, one of the things that Kip Collo did, there was a number of blogger interviews. This is on page 245 of the textbook. And what's interesting is just the level to which Kip Collo was aware that his actions were illegal. I will leak Enterprise Today properly. Are you sure you want to do that? Why not? First time I speak with a real leaker. To be honest, I've leaked things before. When do you plan to leak it? When would download and upload on my slow internet? And then it says later on, I have SDK tokens. And then the blogger even responds and says, that's crossing a line, pretty illegal. And then he responds, I know, smiley face. So it goes on and even talks about how it is that the Microsoft even controls Mac access to this information, and how they were starting to get scared. In short, in the end, he ended up getting 3 months in prison. So he had, again, released this information illegally, he had obtained it illegally, and then released it illegally. And in the end, he ended up being jailed for about 3 months for actually releasing that information. Now, last but not least, just want to touch briefly on remedies. So you go ahead and you allege some misappropriation of the trade secrets or the trade secret. And the question is, what can you actually get back after all is said and done? Because to a certain extent, once the cat is out of the bag, how do you get that information back? If you've taken steps for so long to keep it a secret and suddenly the secret is known, how do you rein it in and keep it a secret once again? And that's kind of a hard thing to do. You can't necessarily apply restitution where you can put them in a state prior to the damage actually occurring. So you can apply an injunction, and this would the court going in and indicating to a party, you're not allowed to disclose it, you're not allowed to use this information in any manner. And that may be applied either one, until the information actually becomes public, or two, the owner of that information that is actually maintaining the secret releases them to disclose it in some manner. You may also require damages, or you may be able to acquire damages based off of whatever disclosure occurred, namely actual losses. So if the secret itself is, let's assume that the Coca-Cola recipe was actually released, and it was by a competitor that actually made it publicly known. Well, Coca-Cola could say, the actual losses here are astronomical, because that recipe goes into and contributes to every single Coke bottle that is produced. So in short, the damages could be very high, it could be very low. In the case of Kip Collo, he was definitely not a deep pocket type individual, and so although he may have been selling this to bloggers or even providing it to bloggers, he was not necessarily, that was not a deep pocket that they could use as far as recovering damages that way. So there could be some restitution at defendant's wrongful profits. If the defendant has actually reaped some benefit thereof, they would have to restore that to the owner of the trade secret. Notice that it's not restitution of the knowledge, it's only restitution of the damages, consistent with what I indicated. Punitive damages, that looks at whether or not the person that was misappropriating the trade secret actually took willful steps to both receiving illegal or misappropriated information and then making it known, some disclosure in some manner. So if you knew that it was illegal, if you knew that this information should not be disseminated and yet you still did it, then that may be some basis for punitive type damages. Attorney fees as well that you might be able to recover, consistent with other forms of IP.